thank you all for coming again today. I'm going to start the second of our presentations in this year's Student Scholar Series. As you know, the series was instituted 4 years ago in order to recognize notable legal scholarship produced by members of the student body during the previous academic year and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by second-year student Emily Rubino. Her work, A New Standard for Reliance in Inefficient Primary Markets, was a unanimous selection by the committee this year and was nominated for the competition by Professor David Lipton. And I'd like to thank him for doing that and ask him now to come up and first introduce our respondent for the presentation, Mr. Michael Ryan, and then introduce him herself.
I hope the applause is for AG, not for me. You resolved the problem that I had. I didn't know whether I should introduce Emily first or Mike first, but I was leaning toward Mike because I think he's cuter. They are both people of whom I'm very fond.
You clearly need those.
So it's difficult for me to do this straight, and I'll undoubtedly, in the eyes of many of you, put my foot in my mouth. They know me well enough. Are we recording this? Good, because I want to do a shout out to Emily's mom. Mike graduated from Villanova and got a CPA and came here to the law school, and it was a very distinguished year. A whole lot of people. I didn't know Mike very well, and sometime in the 90s, I forget what the reason was. Mike, I, and some of you might know, remember, what's her face? We all went running on the mall together. She just retired. Who am I thinking of, please?
Oh.
We all remember this. She was on Law Review. She just retired. Anyhow. And I was wondering who this pipsqueak was, who had the audacity to run faster than me on the mall. That was back when I could run. And it turns out he had been a student back at Catholic. So that was kind of exciting. Mike had this. He reminds me of Frank Sinatra. You know, I've been a pauper, a pirate, a poet, a prophet. You know, Mike's been just about everything in securities law. He rose very fast in the SEC. He then went on to become the right-hand man of the. It was Glauber, wasn't it? Zarb. Frank Zarb of the NASD. From there, they kicked him over to be general counsel of the American Stock Exchange. He came back and ran this program for the capital markets at Chamber of Commerce, and moved on to be the CEO of ProxyGovernance.com, which is an interesting advisory group on for corporations, started by a former commissioner at the SEC. Nancy Rappa was the lady's name. Thank you. And then most recently was the CEO of a group that gives advice to executive boards run by the NYSE. Right now, Mike is taking a deep breath and planning where he's going to go for the future. And I don't know if I'm going to break any confidentiality here by saying that he has prepared a business plan of a project that is fascinatingly Mike brilliant. And all I could say is, if he goes forward with it, I'm making a commitment right here. You got this recorded, David? I will invest in it. So that's Mike. Emily is my research assistant. I've been very, very fortunate to have her and a couple of other wonderful researchers in the past few years. She went to Wake Forest, came and was a Navy SEAL or something like that down at the Navy Yard. It was on law review, which she neglected to put in her bio, small thing. We'll be working with a large firm up in New Jersey this summer, and I asked, well, why are you going there? And she said, because her mom, whose name is Marianne, and that's one word, her mom worked there. So if this goes to Marianne, we want her to get that credit. Anyhow, the topic is what really caught me in the way that Emily handled it. And to simplify it for you all, which Emily will probably do herself, we know that the Securities Acts are designed to prevent fraud and misstatement in the issuance and trading of securities. And in order to cover fraud, you have to cover the question of reliance and causation. In public markets, there is a device that Emily will describe that has been crafted by the courts to do that. Interestingly, the vast majority of our corporate capital does not come from public offerings. By a very large multiple, it comes from privately offered securities. And in privately offered securities, this device that the Supreme Court crafted is not available as a means of showing causation and reliance. And so the question has been, well, we know that statements that are misleading have influence even on these privately offered securities, but how do we show that without this magical device? And there has been a couple of court decisions, I think one other law review article, and then Emily's has come along, and Emily goes back and she looks at what is the purpose of the statute and how do we make these tests, and from that determines what the standard should be for creating reliance causation, which is a very critical and ultimately will be necessary kind of test for this causation and reliance. Anyhow, I will shut up because it's really Emily's talk, not mine. I think that this particular piece, albeit a student note, is going to be widely cited if it goes public. That's it. I'll turn it over to those people who know so much more and who are so much more tactful. Thank you all for being here.
Well, that was a nice introduction. Thank you. I will start by making it a bit more simple and just give you some context before I go in to describe more. So basically, the topic involves fraud in connection with transactions and securities, and specifically claims for fraud that are brought under Rule 10b-5, which falls underneath the Section 10b of the Securities Act of 1934. And I did just want to also mention there are other provisions that provide private remedies for fraud in the Securities Act, but they're more narrow. So really 10b-5 is the main vehicle through which plaintiffs are able to redress their claims. So that's another reason why this is an important topic too. Okay, so the specific issue involves reliance, which is an element of a 10b-5 claim. And before that, I'll start by saying that the Rule 10b-5 cause of action has been very much judicially created. The lower court started implying a cause of action underneath it, and for that reason, a lot of the elements have been kind of grafted along the way and taken from common law deceit, and there is some disagreement as to whether or not there should be an implied cause of action, although both the Supreme Court and Congress has clearly acquiesced in that. But for that reason, some of the elements are kind of unclear, and there's still some problems in a lot of them. And as Professor Lipton mentioned, the main problem here is with proving reliance and the evidentiary burden it places on plaintiffs. And as he mentioned, there are various theories that the courts have developed to address this issue. And one of the theories is fraud create the market theory, which originated in the Fifth Circuit. And that's really where my paper talks about that theory, because what is good about it is that it solved or tried to solve one of the problems of providing a mechanism for proving reliance and allowing plaintiffs in these markets to invoke a presumption of reliance, which they weren't able to use the other theories that are available when you have an efficient market, and I'll go into exactly what that means. So they were kind of on unequal footing, where in some market contexts you had plaintiffs able to take advantage of a theory for reliance that allowed them to get over some of these evidentiary hurdles, whereas in these markets you didn't have that, and there was no real justification, in my mind, for that imbalance. And the problem with the Fifth Circuit's theory is it's not very widely accepted, and part of the problem is the standard that they use in their articulation of the theory. I need some more guidance and more structure to make it more clear and more workable in other circumstances. So I think the best way to start is just to explain that the Supreme Court has recognized that reliance is an element of a 10b-5 claim, and just to remind us what the purpose of it is. And it's really to link the harm that the defendant is posing to the market with the actual plaintiff's injury and the plaintiff's decision in this circumstance to transact in the securities market and to buy or sell. And a quick overview of just kind of some of the issues with the reliance requirement. One aspect is the class certification problem. There's obviously going to be a lot of different reasons why individual plaintiffs are relying on these statements that have been made. So that's going to be hard to satisfy the predominance requirement. But in my mind, that's not really the main, that is a big issue. But I think it's more about the context in which the securities, transactions in securities, the markets for them are a bit different from the impersonal markets that common law fraud really sought to address, where you had face-to-face interactions. And here you have markets that, the very fact that we even have regulation to force disclosure and these purchases, it gives some indication that it is a different context. And I think that's important to recognize. Another case, too, is in omissions. The Supreme Court has said you can get breach when someone has a duty to disclose and you have breach of that duty. You can then get fraud just by showing materiality of the non-disclosure, and you don't have to show reliance. You're entitled to rely on the fact that there was a duty and the fact that the non-disclosure was a material. And I think overall the important thing to note, too, is because the Supreme Court has said that they are showing a willingness to relax the reliance requirements in certain circumstances. So they're already setting out kind of a framework for a situation where you don't have to stay within a strict confines of what may be acceptable in common law fraud. And I don't know if I said this, but the reason why I go back to that is when the courts were creating this cause of action, they really were looking at common law deceit and taking a lot of the elements from that and incorporating into this claim. So as I just mentioned, there's two current presumptions, or presumptions of reliance, or theories on which they are based, and the first had to do with emissions, and the second one is kind of the big one that we're going to say is analogous. We want an analogous theory to kind of match up with, and that's the presumption that was established in Basic v. Levison. And in that case, this is a theory based on an efficient market hypothesis, and I'll explain that in a second. But what this does is it really alleviates a lot of the evidentiary burdens for plaintiffs in proving reliance. And the biggest thing here is you have to prove the existence of an efficient market, and there's many markets where that's not the case, and as Professor Lipton mentioned, the private markets don't have that. So that's the key component that's missing, just to keep in mind. So efficient market hypothesis basically basically says that when information is disseminated to the market, that information is incorporated into the market price because the security is heavily traded. And the market does not distinguish between bad information and good information. So when information is being presented to the market and it's being incorporated because it's heavily followed, then that's taking the bad information with the good. So when you're a purchaser and you're relying on the market price, you're looking at a price that has presumably taken into account all the information available, good or bad, and in that way you're indirectly relying on the misstatements that are out there. And so that's one way of saying there's an indirect reliance, and you're not necessarily having to read the misstatements that were in the disclosure documents or a misstatement that was in a press release, or can just say I purchased based upon the integrity of the market price. And that's something that's really allows, you can see in a class certification situation, very easily to resolve that issue, and very easily to resolve an issue where perhaps you weren't aware of some of the information either. And I think the best thing about the court's analysis in BASIC, and this was the Supreme Court that kind of sanctioned this theory that had been out there, is that they really show reliance in terms of causation, which makes a lot of sense. And the way that they say it is you just have to show any theory that shows the requisite causal connection that somehow links the wrongdoing with the inducing the plaintiff to enter into the transaction. And it's really that. And it's actually been called transaction causation by a lot of the courts subsequently. And I think that's important because then you can kind of think about it in terms of a causal chain and how far, when you're thinking about a new theory for a different market, you can kind of think about, well, how else can we link these events together that makes sense in a way that creates that causal chain that we need. And that's how I'm going to go about analyzing both fraud in the market theory a little bit more, and then fraud created the market theory, which is the theory that's in the Fifth Circuit for the inefficient markets. So, actually, well, then I'll just start with fraud created the market theory. As I said, it was really born in the Fifth Circuit, and unlike fraud on the market theory, which says, here's this information, here's this hypothesis that we have about how information is disseminated to the market and how it's incorporated into the market price, this doesn't have that basis. Because as I said, if you have an inefficient market, then information is not being readily incorporated into the price, and you can't rely on that. But this is saying something different. This is saying that there is reliance on the fact that the security is even brought to market. And it really is just a proposition that there's a baseline market integrity that investors are entitled to rely on, and to some extent. And that's what and that's really what it's saying, is that it's not necessarily a high standard, but there is, through our system of mandatory disclosure, through our manipulation regulations, and there's some basis to say that there should be a certain level of integrity afforded in the market when you go to purchase, and you can subsequently rely on that. So the facts of Shores are kind of important to some extent. And that case involved a municipal bond that was being issued, and it was actually a revenue bond. So the promoters had to promise to at least pay a certain rent on it, and they knew at the time that they were bringing the bond issue to market that they wouldn't be able to meet that financial obligation. And in fact, the other people involved with the process of bringing it to the market, the underwriter, the accountant that they employed, the lawyer that they hired to draft up the offering documents and to help them bring the bond issue to market, they were all involved in subsequently for another investigation on something else that the SEC was investigating them with. And they kind of there was this collusion of fraud where they were all going to induce the local board to get them to allow the municipal bond offering to go through. And really you see here a fraudulent scheme to bring this to market, and that's what what the problem is. So it's not necessarily even just a misstatement, but it's just the entire fraudulent scheme to focus on. And I'll just get back for a second. And really what the Fifth Circuit was saying is that in this case, those securities were not entitled to be marketed because of the pervasive scheme. And they have a standard, and this is really where the theory gets problematic, is in saying that there's a certain baseline integrity into the market and there's a certain point to which you can say a security is not entitled to be marketed. That's where the confusion with unmarketability comes into play. So they have a standard for unmarketability. In this case, the Fifth Circuit goes with the economic theory of unmarketability, and their idea is that because of the pervasive fraud, if all the facts had been known, if the underwriter and the accountant and everybody else involved had full and accurate disclosure, then in that case the bond would never have been, nobody would buy it, there would be no market created for it. And that's a little problematic in the sense that they're positing a situation where the bond would be worth nothing. And that's, a lot of courts have had a problem with that. And the other situation is legal unmarketability. There's one case where, it was a Seventh Circuit case, where there was a law within the state that said that the agency wasn't allowed to approve of the issue because of, well, actually, I'm sorry, in that case it had to do with they didn't have authority to go ahead with the bond issue because it wasn't a public entity. And that's a case where a law was specifically saying that this could not go forward. And then factual would be in that specific case, you could go through and you could pinpoint something that would say that, if one of the participants had acted differently, then the securities were never brought to market. So a lot of courts have the Third Circuit has had the most articulate explanation of the problems having to do with the fraud created the market theory. And the main problem has to do with the standard for unmarketability. It's very hard to understand what is an unmarketable security. That's part of the problem with the economic unmarketability standard is that it's hard to distinguish between fraud and a worthless security and fraud where a security has some value. So it's conceivable that in some circumstances the security would retain some value even though there is fraud. And there may also be another situation where it's just highly speculative and maybe it doesn't have any value, but that doesn't mean that at the time it was issued there was value, or at the time that it issued there was fraud. So the Third Circuit's contention first is with the economic theory. I explained that they think to some extent that there's most likely to have a situation where the security would be in market and wouldn't be worthless, and it's very hard to start to defining what worthless is. But the other problem that they see too is just with the fact that they find that the participants in the offering process have so much incentive to go along with a fraudulent scheme that it doesn't make sense to rely on them to stop it. So specifically, the underwriters have an incentive to overprice, and they're also saying that everyone's kind of pursuing their own self-interest, the attorneys, the accountants, that there's no rational reason, it's not reasonable to rely on one of those participants to kind of stop it. And the SEC as well does not engage in any type of merit regulation where they're reviewing the security and saying that they can't go forward for that. They are just saying that you have to have these disclosure documents, and you read the disclosure documents, and then you make a decision and decide. Our job ends at providing the information to you. So that's the other main issue with that. And then there's policy concerns. So that's the other thing is the Third Circuit had said that they're concerned about strike-through suits and just that this is going to promote a lot of vexatious litigation. And Congress, I think it was in the 90s, they had a Litigation Reform Act where they really sought to kind of constrain the 10b-5 cause of action, which, as I had mentioned, was an implied cause of action to begin with. And that has caused a lot of courts some concern about expanding the scope of this, and that really, to some extent, was the Third Circuit's concern. And also, the Third Circuit had a lot of emphasis on the fact that the securities laws are designed to facilitate full disclosure of information and bringing this information to market, and not so much looking towards promoting a certain level of market integrity. So they did reject the idea that there's an optimal level of market integrity that the securities laws together are designed to facilitate. And also their last point was the two other presumptions in BASIC and the other presumption that had to do with omissions. They're saying that if you accept the Fifth Circuit's theory, then these two theories would be superfluous, because if you just can rely on the fact that the security is on the market, then you don't need to start getting into efficient market, non-efficient market, or whether or not there's been an omission, there's a duty, and materiality. So my proposal was to, again, I had said I thought that the Fifth Circuit had a good idea where you needed to provide an analogous theory for Reliance in this alternative market where it's not efficient, you can't take advantage of fraud on the market theory, because there's really not a lot of difference between somebody relying on the integrity of the market price and somebody purchasing in the behavior that the plaintiffs in the Fifth Circuit case did. I mean, they to some extent, they just said they had heard a recommendation casually that they wanted, that municipal bonds were a good thing to buy, and they just bought anything on the market, not really taking the time to consider specific things about that. And that might be consistent with some of the purchasing behaviors of people on the efficient markets, and they don't have to show anything else. But I thought that if you go back to what the Fifth Circuit's saying, in a lot of respects, they're really saying we're getting past misrepresentation and more towards fraudulent conduct, which goes into, if you look at Rule 10b-5, there's two parts of Rule 10b-5 that actually impose a prohibition against deceptive conduct, and that's more manipulation and not just misrepresentation. So part of their reasoning is that this scheme of fraud is so pervasive that the misrepresentation in the offering documents, which the plaintiffs did not read, were really just one, subsequent step in a huge scheme to fraudulently market the securities, and thus holding the plaintiff to that specific reliance on a specific document would not make sense in that circumstance. And so one way to get away from all this, the main problem with the Fifth Circuit's theory is why their concept is good. The fact that they're focusing so much on the worthlessness of the security is really the problem with it, and they really need a better standard for evaluating whether or not something is worthy of having this presumption. And I thought that you could switch to the intent of the promoters in that circumstance and show their intent to fraudulently market the securities rather than focusing on the value of the security, and that eliminates a lot of the problems with determining, well, was it just speculative or was this really intent that would make it sufficient to come within the other provisions of Rule 10b-5. And the other thing, too, I mean, I would like to challenge to some extent their idea that it's not reasonable to rely on any of the entities in the process of bringing the security to market, because there's players who are self-interested. They still have some liability under the securities laws to due diligence requirements, and they also have liability under manipulation provisions that prevent that. And there's also a lot of there's some theories that too that underwriters would underprice and not overprice. So when the Third Circuit was saying that, I don't know if they were completely correct about that. And then there are other policy concerns. I think with intent, when you have intent, in some respects, you're narrowing the class of securities that you have possible claims under, because you're really saying these are very pervasive schemes of fraud and not really just limited to a misstatement in an offering document. So in those circumstances, those securities that follow that pattern would not really be incorporated into this theory. And in fact, if you apply the Fifth Circuit's theory with my intent requirement, the facts of the Third Circuit case don't really fit. It would fall outside of the theory because there's not, in that case, it was just more negligence and not intent to defraud. And then finally, I think that Congress was concerned with market integrity. For them to say that Congress didn't want to afford a baseline level market integrity is not really consistent with a lot of the goals of the 34 Act that prohibited manipulation. And the 33 Act, to a large extent, was involved with facilitating information disclosure. And there's mechanisms within that act to kind of force compliance with that, and that's not really the goal of 10b-5. And that's it. So, pass it to you.
Sure, thank you. First of all, I will stress that if others want to ask questions along the way, I think I'm supposed to encourage that. First of all, I think the paper is well done, and I thought your presentation was also very well done. I want to start by stressing what Professor Lipton and Emily said up front is the importance of this topic, and I want to add sort of a few comments around that. If you believe, as I do, that, and I think the evidence bears this out, that small companies are really sort of the driver of economic growth and job creation, and particularly coming out of the financial crisis, we need to be sort of more worried about the capital formation process around for small businesses. And critical within the capital formation process is the risk of capital. In other words, an investor's willingness to put their money at risk for a small business or in any venture is going to be about the risk associated with investing in that enterprise. And what Emily is focusing on is really companies that are small businesses or businesses that don't lend themselves to trading in an active market. And so if you're an investor looking at that opportunity, when you look at the risk associated with that, one of the factors that I believe you're going to consider is that if something goes wrong, what is your opportunity for redress? And if the law basically says because there is no liquid market, the ability to use 10b as a remedy goes away, then from your perspective, the risk of that capital, of investing in that enterprise, goes up. You know, that your exit strategies are limited, or become more limited, and your opportunities to get your money back are limited. Therefore, you're going to say that this is now a more risky venture rather than a less risky venture. And so I think that this is more than just a sort of a nice legal argument. I think it's one that really does have implications for our economy. And as Professor Lipton pointed out, you know, a great deal of economic activity does happen away from the public active markets, and so we sort of all need to be worried about this. So, Emily, I think it's a great topic. I would say it's a great topic at all times. This is always an issue, but coming out of the financial crisis, I think it's one that's really critical. So, one comment I would have as you go forward with this paper is to spend some time up front, sort of telling that story, creating. You don't necessarily need to spend a lot of time on this, but spend some time sort of giving people a reason to care about this issue. You know, and I also think part of that story should include sort of the inherent unfairness of what is at least initially got started here with the Fifth Circuit, which is if the security is worth zero, then you can recover, but if it's not worth zero, then your opportunity for recovery it goes away. Going back to that sort of that risk analysis, I think nobody investing their money is ever really going to believe that that investment is going to ultimately go to zero, and therefore that this is going to trigger some right for them to for redress. So I think that's really a critical part of that story. I also just think overall, I think the paper read very well. The way you logically walk through the background and the prior decisions, I thought was good. As you go forward, I would work on that and do more of that and sort of factor in what what other courts are saying or what other commentators are saying. But I thought you did a very good job of that and sort of created a strong link from one case to the next. And so I think that was great. I want to, one issue that you and I talked about this a little bit in advance, this whole idea of a private right of action under 10b is very well settled law, but it is not without controversy still. There are a lot of people, organizations out there that feel very, very strongly that this was a judicially created right that is clearly not what Congress intended, and even though Congress has had plenty of times to sort of override that and fix it, if you will, from the perspective of those who are against it, it is something that there's a lot of people out there that are fighting against. And so taking that private right of action and expanding it into the sort of the small cap or micro cap world will not be without a lot of controversy and a lot of pushback. So two things I wanted to address, and I hope others will chime in, but one of them is this idea that sort of going to this private right of action. You made a comment in the paper about that this won't sort of add to the litigation frenzy, and I just wanted to sort of discuss that a little bit, tease that out, and because I'm concerned that that there will always be vultures out there, trying to jump in and take advantage of this, this sort of strike suit lawyers.
Well, and I think, when you mentioned that to me earlier, I think my initial response was, that's true, and I think my main problem is that you have an analogous theory in the efficient markets, and that has been accepted with the threat of strike-through suits or vexatious litigation, and that has been accepted to some degree by the courts in acknowledging the fraud in the market theory in BASIC. The Supreme Court didn't have to go there, and I think the problem is I don't understand the inequality in this case for not allowing an analogous theory for the plaintiffs in the inefficient markets. Well, I do agree with you. I think I overstated it a bit in my paper to say that it's not going to present a risk, but I think it's definitely the same risk that has already been presented by accepting it in the efficient markets. And I think also the Third Circuit, they were very concerned about it, and their concern, they also made it seem like the Fifth Circuit's theory would allow any plaintiff at any time to just say that I've suffered a harm, I've suffered a loss, and I paid X price for the security, and now it's fallen, and I'm just going to say my security's on the market, and so I have a cause of action. And while that's true, and that might be an impetus for bringing a suit, I think that the Fifth Circuit's case, and the case that I'm trying to build, is more narrow, and it's really where it's beyond just misrepresentation. It's an entire scheme that is able to be more pervasive than that, and that limits to some extent, at least what they were saying.
So,
I don't want to cut you off. I just wonder if there isn't some guidance that comes from the Public Securities Litigation Reform Act, the 1995 Act, signed by my favorite Democratic president, which really did limit the ability to bring vexatious litigation under 10b, even though by then we had the fraud on the market theory. Now, the limitations that are in PSLRA would not be identical to the limitations that would apply in fraud created the market, but limitations could be placed in similarly. Congress has shown a taste for that already, and I don't see why they couldn't show a similar taste.
Yeah, and I guess bringing this back to, Emily, to your article and to the Professor Lipton, the point that you were making up front of that this article could really have an impact and start to be part of an important discussion around this. I think it's one thing I would encourage Emily to do is to sort of recognize that even though the private right of action is well-settled law, it is not without controversy, even with the PSLRA being in place for 17 years now or so, and that if there may be opportunities for you in your paper without sort of getting diverted to recognize that concern and the need for that concern to be addressed, because even in today's environment, you made the point a few moments ago that has been accepted in today. It is still very, very controversial, and you know, taking an article and making it really practical, I think would that recognizing that without necessarily sort of solving that problem, because it's not solvable in one note, I think could go a long way in making the paper be very practical.
Right, and so the Third Circuit actually cited the PLSRA for a reason that that's a signal for us to cut back and not to expand.
Yeah, and
so to incorporate that more.
Yeah, but and the language from the Third Circuit is sort of an indication of what I'm talking about, which is they seem to be very hostile to private right of action.
A visceral just reaction to
yeah, and that is very much alive and kicking out there.
Yeah, I'm not sure if you're pausing or you're finished, but I think your first two suggestions were great. I think to identify that significance of this suggestion at this particular time in our economy's progress up front would be awful good.
Well, then you have a counterbalancing of the two concerns too. If you're posing the specific problem with the capital formation for small businesses, you're saying this is a significant public interest, and then saying, well, yes, we might incur some more litigation, but here's the benefit of that, and make that more prevalent as well.
Yeah, the benefit basically says that you're in theory reducing the risk of
and that's worth the cost.
And reducing the risk, you're cutting down the cost to the issuer of raising the capital. They're going to get a better price for their shares or their debt instruments.
Yeah, you're increasing the risk of raising that capital to the fraudulent firm, and therefore reducing the risk to the non-fraudulent firm, and that's what we want to be incenting. And so I think making that part of the story, so why should people care about this? You know, it would be important.
Yeah.
Has there been any look at what the impact of your proposal and proposed interpretation would have on the influx of cases? For example, how many problems are there out there, and how many would come into the system? We used to have to file sometimes when we were writing legislation, judicial impact statements.
Yeah, that's a good suggestion. I mean, I think that under the Fifth Circuit's current theory, looking at worthlessness, or certainly under one theory that was posited, where you would look at the case where there was actually a law that prevented the issue from going to market, that's going to be kind of a rare case. So I don't think that would have that much of an impact, but certainly the standard that I'm suggesting would, and that would be something like that. Yes?
I wonder if you could make this a little more concrete for me, so I'm not at the level of David and Mike are. If David invests in Mike's endeavor, and it goes south, and he says, whoa, I need to get my money back, what is the intent that he's looking for? How does he discover that intent without filing a lawsuit? And if he files a lawsuit, how does he get by the Iqbal pleading problem to get to discovery?
I think that's another concern that I had originally, was that you're taking factual problems with worthlessness of security, and there's also problems with showing intent. And I think that in the case of the Fifth Circuit, if you look at the facts of that case, I think a lot of circumstantial evidence just showed the prevalence of a fraudulent scheme. And like I said, it was the fact that one fact you could point to is that there was the same defendants, the same accountant, the same underwriter that had done this before, and in fact were under investigation. And when it became known that the one issuer wouldn't be able to do it, or the one underwriter wouldn't be able to carry the bond issue, which had to do with something to do with his conduct, I don't remember precisely what it was, they actually colluded to induce another underwriter to kind of come into the scheme. So I would look to, it's difficult, but I would look to facts like that to show intent. In the case of this, I wouldn't, if, you took it to market and it was a disaster and you wanted your money back, I think that you could show recklessness or negligence maybe, but you wouldn't, I don't think you would have a cause of action under this theory, and that's, the Third Circuit was trying to say that you would, and that's the point.
Yeah, and that's why I was raising this whole issue, that I think that Emily would be well served by sort of addressing and recognizing the reality of frivolous litigation and take some steps, or if there's opportunity to say, start to craft a solution or point in the direction of a solution, because that cost of litigation also is a cost of capital as well, and the risk of a company ending up in litigation becomes a cost of capital. So there does need to be a balance there, I think.
Sandy, I'm glad you asked that, because I was thinking it as well. Let me just point out initially that the difference between Mike going forward with that in the public market and Mike going forward with that in the private market is that in the public market there are going to be a lot of analysts who are going to follow this, and they're going to absorb that, and that's going to be the price break. So it's not there. Now the second consideration is that very often in both public and private market, the investor isn't really reading the disclosure document, but they're relying upon things. So I'm relying upon Mike's past reputation in the industry, and I'm saying, okay, this is a good investment. What would be the standards to show intent? I don't know, but I can give a couple of ideas. For instance, Mike goes forward, I buy shares, and then it turns out that Mike really did not have had taken no initial steps towards setting up what he said he was going to set up. It's just that it didn't exist. There were no other investors other than me. That wasn't disclosed. Mike had tried this 3 times before in the Cayman Islands, and it didn't work out, and that wasn't known. All of those are just examples of what could demonstrate the intent. I really don't know what's on Emily's mind as to intent, and I don't know whether or not that would be consistent.
It is, well, and also working off of that, in this case, not to get you off, sorry, you could show there was very clear evidence that at the time they went ahead with the bond issue, they knew they did not have any intention of manufacturing the homes. The underlying business had no capability to do what they were going to do, and they had no financial capability to even pay back the rent that was due on the revenue bonds, which required them to pay back the lease, and that they had no financial capability of doing that.
That's a good example.
But you also raised an important question, which sort of, how do you even find any of that out? In some cases, and maybe some of these it's obvious, and in other cases, not so obvious.
In my attraction to the intent standard, even though there are still factual problems, just like with the worthlessness, I think logically and theoretically it's just more sound than saying that the worthlessness of the security should be the standard, because not only is that factually difficult, I don't think it makes a lot of sense logically. So.
And you have to read, at least as the Third Circuit case, to see them playing around with the concept of worthlessness. Security, which just is so irrelevant. There are no securities that are worthless. Even Lehman Brothers, after it crashed, was still trading for pennies, so was WAMU. Nothing is worthless. And you.
One other thing that I would mention too is just sort of transitioning to maybe one last comment is you seem to be accept the doctrine in Shores in terms of creating this new theory, but then you take a leap and say don't do it based on whether there's the securities are worthless or not. Do it on what the intent is, and sort of to what extent would the Shores court accept that, and so I would work through the best you can how acceptable that would be to the different courts.
I think one of the reasons why I think they would accept it to some extent is because when they were going through the reasoning, they really looked at the fact and they focused on this is not going to be, there's 3 causes under Rule 10b-5, this is not going to be for misrepresentation, this is going to be for conduct that's beyond a misrepresentation in a document, it's actually conduct that's deceptive and falling under A and B, which that clearly shows more of an emphasis on intent than on, I think, their worthlessness standard. I think that was, maybe that's how they were trying to show intent, was through worthlessness. I think that's kind of more accurate to say that they were looking for a tangible indicator. They're trying to make intent less abstract by saying worthlessness shows fraudulent intent. And I don't think that helps to facilitate. Thanks, sir.
Guys, I see AD moving and many people already. Should I bring this to a close for you, or
I think it's, I just want to thank Emily for an impressive presentation of a complex topic. For a wonderful response to it, and Professor Lipton for helping negotiate the conversation. Again, we part with Emily with giving her a strike that box. That's the president side of it, and thank her for being a second student scholar this year. Hope you can come next month when her beach will finish this series for us. Thank you.